But good morning, everyone. Welcome. So really pleased to have you join us this morning. So this is our last event as the French Chamber before we break for the summer. So really delighted that we could get this in. This is a session with Dawn Clayton and Helen, Dan, and Malina from the employment law and immigration team there, which is a really good opportunity for us to reflect on. Well, we've had some interesting politics changes, obviously, and a new government coming in, and then the King's Speech, which has laid out the agenda for that government for the next session. Still relatively light on details, but I know Dan and the team will talk us through what we have. And there's a few bills there were a lot of bills, 39 bills in total, and there are a few bills that we're going to focus on today, particularly around border security, asylum and immigration, employment rights, race equality, and so on. So the agenda for today, we're going to focus on employment law, upcoming changes. There it is on the screen. Day one rights for employees and the implications of that, what businesses need to be thinking through. Equality changes as well, and new proposed duties for employers, and some of the objectives that the Labour government has laid out in terms of immigration changes as well. So that's the session for today. Just before we begin, I just wanted to flag a couple of things on behalf of the French Chamber. So we do a lot of advocacy work and impact work, as you know, led by David Lutton in the team here. And that's, highlight of that is our Franco-British Business Forum, which we run twice a year with both embassies in London and Paris. We're extending that work and we're doing more. So this is just an open invitation to everybody to get involved. We really want our members to kind of feed into that, engage with that work as much as possible. I'll put a link up for more details. Part of that in the last week, we've launched a manifesto. I mean, it's manifesto light, but it's just a few of the topics and areas that we're flagging as a French Chamber on behalf of our members, which we would like the government to focus on and we'd like to be a part of in terms of the conversation. So again, I'll put a link in the chat at some point. And if anybody has any kind of feedback or wants to engage it with us on that kind of work, please do get in touch. Another quick shout out is for our Franco-British Business Awards held at the end of November. This is a real celebration of French businesses in the UK. There are five different categories, 5 different awards, and it really is. We've made it as easy as possible to apply and put your applications in. It's a chance for you to highlight the good things in your businesses across a range of different areas. So please do engage with that. There are also opportunities to sponsor and support us with that event as well if you want to kind of feature in that too. So again, please do let us know. Just before I hand over to Dan and the team, just to flag today. So this is, we'll have a session led by Dan, Helen, and Malina. They've got some fantastic information for us, but then there is lots of space and time for a Q&A at the end. So please do store up those questions. The format for that, if you can put your questions into the Q&A function within Zoom, and then we can triage those and put those to the team as we get into that part of the session. If you have more in-depth, specific technical questions, the team at Dawn Clayton are very happy to receive those by email as well. So again, we'll give you the kind of contact points for getting in touch with them. If you've got more specific things, we'll try and keep things to the general today rather than deal with specific issues. And we will share the slides with you as well. So all of these slides will be circulated, so you don't need to take notes. So that's fantastic. So again, thanks to Helen, Dan, and Malina for joining us, and over to you, Dan.
Francois, thank you very much for the introduction and good morning to everyone. We'll talk for about 35 minutes before we take questions. As Francois mentioned, there were quite a lot of new employment law changes announced on Wednesday. We're not going to be able to cover all of them simply because there were so many. There were also a lot of proposals announced in Labour's manifesto before the election. We have done a briefing note, which we can share with you later on the manifesto. So that gives you some more context about what might come up in the future. But today we're going to focus on the most significant new legal proposals announced this week. The bad news, I'm afraid, for employers to start with is that if these proposed laws come in as Labour is planning them to do so, they're likely to result in an increase in administration for you, an increase in legal risk, and more management time being needed to deal with matters. So before we move on to what was announced this week, let me just quickly hark back to what happened the last time we had a Labour government in power. That government introduced a whole range of new employment law legislation, ranging from the National Minimum Wage Act to protections for different types of workers, plenty of different discrimination protections, and flexible working rights and family-friendly rights. And this is relevant because some of the new legal proposals announced this week link back to those laws brought in under the last government, and they develop and extend those protections that were brought in. And the second point, which I think is relevant, is that we expect this new Labour government to be just as prolific as the last Labour government when it comes to introducing new employment laws. So I think it's going to be a busy time for employers and employment lawyers as well. So what was announced this week? Well, there were two significant legislative proposals announced in the King's speech on Wednesday. The speech is quite light on detail, but there's a more detailed briefing note that the government produces to go with it. The first big announcement was the Employment Rights Bill, which Labour says it will lay a draft of before Parliament within 100 days. And Labour's talking about this bill as the biggest upgrade to workers' rights in a generation, i.e. since the last Labour government. And in particular, it's focusing what it's describing as day one rights and protections that employees will have immediately when they start employment, rather than having to wait a certain period or to work for you for 2 years, for example, to get unfair dismissal rights. So that could be a substantial change if brought in as proposed. There's an interesting note in the briefing note prepared by the government where they said extending protections to workers from day one will encourage more workers to switch jobs. In other words, the government thinks, well, if we give you rights from day one, you'll be more encouraged to switch jobs because it'll be less risky for you. And then it says switching jobs is associated with higher wages and productivity growth, because wage rises are around usually 3 times higher for those who move jobs compared to those who do not. Now, I'll let that sink in for a second, but it sounds like slightly odd logic to me. Essentially, they're saying, well, if we give you more protections, you'll be able to move jobs more easily and negotiate higher pay rises when you move jobs. So that seems to be shifting some burden in terms of increasing growth onto employers. I'm not sure how well that stands up to analysis, but anyway, that's what they've put in the guidance note for now. The second big announcement on Wednesday is the proposed new Equality, Race and Disability Bill, which will extend equal pay legislation to unequal pay in terms of race and disability. And I'll talk a bit more about that as we move on here. First, a health warning. These are proposals. These are the laws as Labour is proposing to put them in front of Parliament. Most of the legal developments that we're talking about will need to go through both houses of Parliament and will be debated, and they'll need to go through consultations with stakeholders on various aspects. So businesses will get, and employment lawyers will get a chance to respond to those consultations. So of course it may be that the laws are not brought in exactly the form proposed. They may be watered down, but at the moment we have to assume that this is what's going to happen. Labour's focusing very much on these day one rights. It's very important to them. We've already had some Conservative objections to the day one rights. Rishi Sunak yesterday said that he felt that the imposition of these day one rights would stagnate the economy and would be a negative for employers. So we'll have to see how these things develop. Moving on to the first big proposed change. Most of you will know that in the first 2 years of employment, employees are not very well protected as they don't have unfair dismissal rights. You've got to work for the employer for 2 years to get that protection, although in Northern Ireland, it's 1 year. There are some special cases where you don't need to have the 2 years employment. So if you're dismissed because you're a whistleblower or because of pregnancy, then you have an automatic unfair dismissal claim. Now, what Labour's proposing here is a seismic change. It will take away that qualifying period and employees will have unfair dismissal rights from day one. So you can immediately see that would have a huge impact on recruitment and hiring and on terminations of employment. To give you some context, the qualifying period has never been as low as that. The lowest it has ever been is 6 months when unfair dismissal legislation was introduced in 1971. And it was 1 year for a long time up until 2012 when the Conservatives made it 2 years. So it may be that in the parliamentary debates and consultations that this period does not become a day one period and maybe it moves to 6 months or a year, but we must expect that Labour will follow through on its proposals. At the moment, it has a substantial majority in Parliament. There will, however, be an exception for probationary periods. Labour says employers will still be able to dismiss an employee during probation as long as they follow fair and transparent processes. What we don't know at the moment is what the detail about probationary periods will be. We don't know if there will be a limit to how long a probationary period will be, whether there'll be a limit on extending probation. So all of that detail will need to come out in the draft legislation. With impact of all of this, if it comes in, is obviously it's going to change recruitment processes. It's going to impact probably how thoroughly you interview and vet people before you hire them. You might be less willing to take a chance. You might also be considering hiring contractors who don't have the same legal rights compared to employees. And obviously, there's an increased risk of claims if people have unfair dismissal rights at an earlier stage. Things that you might want to start thinking about now are employment contracts. You're going to need to have very clear clauses about probation periods. Clearly, that's going to need to be updated once we see the legislation. And the other point is managers. Managers are at the coalface. They are the ones who are monitoring performance of new joiners, who are monitoring probation periods. So they're going to need to be trained and to understand the new law and obligations. Moving on, I have a couple of slides about proposed changes to trade union legislation. And I know many of you on this seminar today may be involved in businesses that currently have no involvement with unions at all. So you may think, well, this is not really relevant to us. But actually, there are a couple of new changes being brought in which could be relevant to you. Firstly, a bit of context. As you will, I'm sure, be aware, under the Conservatives, there was a gradual erosion of union powers and limits on the right to strike. Labour aims to roll some of that back. It's going to update trade union legislation so it's fit for a modern economy and remove unnecessary restrictions on trade union activity. And how it plans to do this? Well, some of these measures have been announced in the Employment Rights Bill on Wednesday. It's planning a lot of changes. Firstly, it's planning to repeal the recent legislation brought in on minimum service levels during strikes. It's also planning to introduce electronic balloting. So the impact of that will be, obviously, it will be easier for unions to get votes from their members, and it will reduce the higher thresholds and greater restrictions brought in by the Conservatives on organising industrial action. So the Conservatives increased the notice period that unions have to give to employers. They increased the ballot thresholds that needed to be passed, and they required that industrial action mandates would expire after 6 months. So we can expect to see those protections rolled back to make it more straightforward for unions to strike and to get the mandate to strike. And then the last 3 bullet points are the ones that I think could be interesting and relevant for employers without union involvement at the moment. Firstly, Labour plans to simplify the statutory recognition process. What that refers to is a union can get recognition from a business by agreement. But if there's no agreement with the business, then the union has to follow this quite complicated statutory recognition process. And even then, if it succeeds, it will only have very limited collective bargaining rights relating to pay, hours, and holiday. So Labour is planning to simplify this process to make it more straightforward for unions to get recognition. Secondly, Labour is considering introducing a reasonable right of access for unions to workplaces. It's talking about accessing workplaces in a regulated and responsible manner on appropriate notice. And where that could be really impactful is businesses where there are a lot of remote workers or gig economy type workers who don't have a centralised workplace. And this measure could allow unions more easy access to those workers. And thirdly, it's going to introduce a new duty on employers to inform workers of their right to join a trade union. Now, that may be something as simple as requiring you to put a clause in the employment contract to notify employees of this right. But of course, it also shows the direction of travel, which is increasing visibility of unions and the ability of people to join them. So what can you think about now? Well, even if your business has no union involvement, it's not to say that these changes are suddenly going to mean that you'll have a unionized workplace, but you could think about proactive employee relations strategies if you think it might be a risk. And that could include thinking about, well, if you don't want to have union involvement or want to try to dissuade it, could you set up some other type of employee forum or works council to give employees a voice that might be seen as a good alternative to that? Moving on, we'll start talking now about discrimination and harassment and the changes being proposed in this field. I'm going to talk here about a law that's already coming in October. And it's relevant, you need to know about it anyway, it's coming in soon, but Labour is planning to gold plate it. So you will be aware that harassment's already unlawful. It's unlawful under the Equality Act and other pieces of legislation. This, the new Worker Protection Act that's scheduled to come into force at the end of October, will put a new proactive duty, a preventative duty, on employers to take reasonable steps to prevent their employees from being sexually harassed in their employment. So that means you've got to take reasonable steps to prevent your employees from being harassed by their colleagues, but also potentially by third parties like customers and suppliers who, of course, you have less control of. So that is a very quick summary of the law as it's scheduled to come in anyway in October. Labour has said it plans to strengthen the duty so that it's all reasonable steps, which is obviously a higher threshold for employers to have to satisfy. It will mean that you have to do more. So you should already be thinking about what reasonable steps you can take, and that to satisfy your duty, and that will include all manner of things such as ensuring training is up to date, you have good complaints channels and policies, and people are aware that harassment is not tolerated and so on. And depending on the type of business you're in, there will be other steps as well. But if it's strengthened to all reasonable steps, that sets the bar higher for you to discharge it. Now, employees won't at the moment have a straightforward claim against you if you don't comply with your duty to take reasonable steps. How it will work is if an employee brings a claim of sexual harassment in the tribunal and they win that claim, then the tribunal may look at your failure to comply with your duty and be entitled to award increased compensation of up to 25% to reflect the employer's failure to comply with its duty. The other impact of this legislation is that the Equality and Human Rights Commission are going to have the power of investigation into employers not complying with the duty and an enforcement power as well. The other change that Labour's proposing here is to make employers liable for third-party harassment. This has been a proposal thrown around for the last 10 or 15 years at various points, and it looks like Labour's now going to seek to bring it in. Obviously, that will be more troubling because you clearly have less control over third parties, and we'll have to see how the legislation evolves on that front. Before I hand over to Helen, I have a couple of slides talking about the Equality, Race and Disability Bill that was announced on Wednesday. So there were two significant measures here. Firstly, about equal pay. So to give you, again, a bit of context, we've had equal pay protection in the UK since 1970, and broadly that requires that men and women who are doing equal work should be paid equal pay. And that applies to the terms of the contract as between men and women doing equal work. Now, that legislation was rolled into the Equality Act in 2010, which also covers all manner of other discrimination protections. And the Equality Act allows an employee to sue their employer in relation to discretionary pay as well. So if you believe that your discretionary bonus or discretionary pay rise has not been as good as a colleague with a different protected characteristic, you can sue under the Equality Act. But at the moment, it leaves a gap where it's much more straightforward for a woman to bring a claim that she has been unequally paid compared to a man who's doing equal work to her. But on the other hand, very complicated or not possible for somebody to make that claim based on unequal pay due to race or disability. So the proposal announced on Wednesday is that the government is going to extend the equal pay regime to cover race and disability, and it's talking about enshrining the full right of equal pay in law. So it will be more straightforward for employees to bring unequal pay claims based on race and disability. So there's a risk of more legal exposure, and that also then requires you as employers to think about where you have pay gaps or inconsistencies in your organisation and whether or not you have any justification to that, or it's something that needs to be addressed. And on my next slide, I'll be talking about something that might possibly crystallize some of those claims, because we have an extension to the duty to carry out pay gap reporting as well. So to give some context, since 2017, large companies with 250 or more employees have been required to lodge or publish a gender pay gap report each year, published on their website normally, setting out the disparities in pay in 4 different quartiles of the business, with the idea that by publishing these reports, employers will show how well they're doing, but also be able to identify gender pay gaps and take action to deal with them. So that's the law as it stands. At the moment, there is no mandatory obligation to publish an action plan to go with your report, although some employers do it. Action plan means what you're going to do to address the gender pay gaps, what steps you're planning to take. Labour is planning to make the action plan mandatory. So if that's the case, then each year when you publish your report, you will also have to publish an action plan saying how you intend to address any gender pay gaps. And the second change is that it's planning to include outsourced workers' pay in your reporting obligations. So at the moment, you just report on your own employees and the pay gaps there. But by including outsourced workers' pay, Labour thinks there'll be a more holistic review of pay within the organisation. Now, that's going to pose some technical problems because you may not have access to how much your outsourced workers are paid. So that's already one issue that will need to be dealt with, and it's going to make the process of reporting more complicated for you. But what's underpinning all of this is that Labour says there's still a pay gap of over 14% in the UK. And in the briefing notes, it says there are effective actions employers could be taking, but in 2018, 2019, I'm not sure why the figures are so old, but it's talking about 2018, 2019, only an estimated 52% of employers published an action plan. So it feels that there's more that employers could do, and it's going to increase the burden on you in that regard. And the related announcement is there will be an extension of your pay reporting obligations to report on ethnicity pay gaps and disability pay gaps as well. So again, this applies to companies with 250 or more employees at the relevant date. Clearly, that's an increased burden for you. What Labour says is surfacing pay gaps will enable companies to constructively consider why the pay gaps exist and how to tackle them. So essentially, saying that sunlight is a disinfectant in this case, and it wants to see all that information published. Now, this is likely to be more complicated, and I wonder if the legislation is going to take a little bit longer to work its way through Parliament and consultations, especially because when you think about the technical aspects of it, it's going to be tricky. When you had to report about gender pay, it was probably more straightforward for you to have access to data about men and women in your organisation and how much they're paid. But in the case of ethnicity and disability, you may not have that data. You may not have data about what ethnicity your employees have or identify themselves as, and what disability they have. They may not have disclosed it to you. You may not have asked for it. So a key consideration here is going to be what categories of data are you going to need to have, and how are you going to need to collect them? Meanwhile, while we wait for that detail, things that you can start thinking about are ensuring that your systems are in place to allow smooth implementation of pay gap reporting. You could also start considering things like job evaluation schemes. So those can help identify inconsistencies in your organisation and help you identify pay gaps in advance as well, and other short and long-term measures relating to hiring, career progression and retention, all of which may help close those pay gaps. So with that, I will hand over to Helen, who will continue.
Thank you, Dan, and good morning, everyone. So I am starting this morning with pregnancy dismissals and the new protections that are coming in for pregnant women and new mothers. So this is one of the family-friendly reforms that was mentioned in the King's speech. It will be included in the employment bill, and it will be unlawful to dismiss a woman during pregnancy or within 6 months of her return to work, except in specified circumstances. Now, this goes quite a lot further than the additional redundancy protections that actually came into force earlier this year in April, under which employers have to offer any suitable alternative vacancy to pregnant women and new parents who are at risk of redundancy. So if we look at what the current law looks like, its dismissals for redundancy can still occur, but employers have to give the employee priority for any suitable available role during pregnancy and in the 18 months following childbirth. It is, of course, already unlawful to dismiss someone because of pregnancy or maternity, or for a reason that relates to their pregnancy or maternity. But you can see that these new proposals go much further than that, making it unlawful to dismiss a woman during pregnancy or within 6 months of her return to work for any reason except in specified circumstances. Now, those are the magic words, specified circumstances, and you'll see there's quite a lot of magic words that come up in this presentation. It's not clear what those mean at the moment. We'll have to wait for the flesh to be added to the bone. But presumably they would include dismissals for gross misconduct or gross negligence, illegality, and probably for large-scale redundancy where a business is actually closing down. So moving on to my next slide, which is about 0 hours contracts. And this is one of the headline reforms that's been promised by the new government. It was included in the King's Speech and it will be in the Employment Rights Bill. And it's one that's intended to ensure that all jobs provide a baseline level of security and predictability. Now, just as a reminder, what we're talking about, what do we mean when we talk about 0 hours contracts? Well, they're those contracts where the employer gives no guarantee regarding the number of hours work that's being offered. And yet, in many cases, employees are obliged to accept whatever is offered. In the briefing note that came with the King's Speech, on Wednesday, the government said that the number of 0 hours contracts has risen to over 1 million over the last decade. And the Labour Party is keen to end this one-sided flexibility where they feel that workers are the ones who are bearing all the risk. In fact, in their manifesto, Labour had suggested that they would ban all 0 hours contracts, but that commitment has been watered down a little so that they're just now looking at banning 0 hours contracts which are exploitative. Again, exploitative is not explained, but presumably what they mean by that is those which are weighted, those contracts which are weighted heavily in the employer's favour. So what do the changes mean? Well, workers will have a right to a regular hours contract after 12 weeks, and this contract will reflect the hours that they regularly work based on that 12-week reference period. Workers will also be entitled to notice of any changes in shifts or working time. And interestingly, where shifts are cancelled or curtailed, they will be entitled to compensation for those cancelled shifts, and that compensation will be proportionate to the amount of notice that has been given. It's worth just remembering that workers are due to acquire the right to a more predictable work pattern in September of this year under legislation passed by the Conservative government, which is the Workers' Predictable Terms and Conditions Act 2023. It's not clear what Labour will do with this legislation. They may bring this into force, or they may scrap it, or they may use it as a stepping stone to enact some further reforms. So moving on then to flexible working, and this is another one that's actually received a lot of attention in the press and elsewhere. So what the new Labour government is looking to do here is to ensure that flexible working is a genuine default from day one of employment. The government says it will become a day one right for all workers, not necessarily just employees, and that it will be the default, except where not reasonably feasible. Now, there were some recent changes earlier this year, again, that permit employees to apply for flexible working from day one, and also to make 2 applications per year. But when we look at the current law, what we have to bear in mind is that the law is based on a right to request flexible working rather than a right to work flexibly, and that's a really key distinction. At the moment, the requests for flexible working that are made by employees can be turned down on the basis of one of 8 specified business reasons. Now, I mentioned a few moments ago those words, where not reasonably feasible. So that's obviously the exception. what's meant by not reasonably feasible, what's meant by that concept of reasonable feasibility, query whether that will overlap to some extent with the 8 business reasons that we currently have as justification for turning down a request. But that remains to be seen. I do think that one of the practical consequences, well, it's clearly going to be more difficult for employers to turn down or to refuse flexible working in the future. But I also think it's going to be more difficult for employers to put into place return to office working mandates. And we've seen lots of that post-pandemic, where companies are wanting to encourage people back into the office and they issue mandates requiring office working. That will become harder, I think. So it's a watch this space on that one. Moving on to national minimum wage, this is another headline in the fair pay reforms. It's actually likely to be one of the quick wins for the new government. So the government is going to remove the national minimum wage age bands, which currently provide for different rates dependent on age. So they will want to have a situation where all adult workers over the age of 18 will be paid the same rate. At the moment, we've got different rates for those aged 18 to 20. And you can see on the slide that's £8.60. And those who are 21 and over get significantly more at £11.44. So all adults over the age of 18 will be bumped up to the higher rate of £11.44. The other change that's worth mentioning here is that the government will require the Low Pay Commission to take into account for the first time the cost of living when they make their recommendations to the government on setting those national minimum wage rates. So at the moment, the Low Pay Commission can take into account median wages and economic conditions, but not cost of living per se. And so that will be a change going forwards. It's likely to mean higher national minimum wage rates. And unfortunately, these changes do look like they're going to lead to increased wage costs for employers. Just while I'm on this, just to mention, this may be of interest to those in the hospitality sector. But in addition to the changes on national minimum wage, the new government has made a commitment to strengthen the law to ensure that hospitality workers receive their tips in full and that the workers decide how those tips are allocated. Again, this is likely to be a quick win because there is actually new legislation which requires employers to pass 100% of tips to workers. And that new legislation is expected to come into force in October this year. So again, watch this space, whether that will be extended upon or just used as a stepping stone. We'll have to wait and see. Moving on to parental leave, a flagship reform in the area of family-friendly rights. It will be included in the Employment Rights Bill. And the Labour Party has promised within the first year of government to review the parental leave system and to ensure that parental leave is a day one right. I think we have to look at what's meant by parental leave at the moment. Parental leave is unpaid leave. It's very little used actually in practice. There are very few people who take this. It's unpaid leave and you have to have a year's service to qualify for it. And you can take up to 18 weeks leave for each child until they reach the age of 18. Probably little used because it is unpaid. So obviously what the government wants to do is scrap that 1 year service requirement, query whether they will extend this parental leave review to other parental leave. So for example, we have shared parental leave, we have paternity leave. There is a 6-month service requirement for those types of leave. Presumably that will be scrapped. Again, we will have to wait and see what that review actually means for employers and employees. Moving on to menopause action plans, it is expected that new legislation will be introduced requiring large employers, so those employers that have 250 or more employees, to produce menopause action plans setting out how they're going to support their employees through the menopause. Now, this is an area that has been already discussed quite a lot by the Conservative government, and the Conservative government did actually decide against making menopause an additional protected characteristic under the Equality Act. But what they did do is they established a menopause task force, which was intended to share best practice. And they also appointed a menopause employment champion to work with employers to help keep those people who are experiencing menopause symptoms in work. So what do those menopause action plans look like? Well, obviously they will have to set out the steps that employers are planning to take or taking to support their staff through the menopause. It's a possibility that these large employers will be required to publish those action plans, although at the moment there's a question mark around that. The new government also plans to publish guidance, and that will be applicable also to small employers. And the guidance will be on measures to consider issues relating to uniform and temperature, flexible working, and recording menopause-related leave and absence. In terms of some small crumbs of comfort for employers, when it comes to implementing these menopause action plans, I think actually quite a lot of employers will be able to simply repurpose. Well, I shouldn't say simply repurpose because there will be more to it than that, but they will be able to repurpose their existing policies on menopause, health and safety, flexible working, and reasonable adjustments. So it's not something that's going to have to be drafted from scratch. Then moving on to my final slide, and this is on employment status. Now, I wanted to finish with this because this is really big. It's a really big change. It's very radical. It's relevant to a lot of many of the reforms that we're talking about this morning. But I should make it clear that this isn't one of the quick wins, and it's actually not going to be included in the Employment Rights Bill. If there are changes brought in here, they're likely to only take effect towards the end of the Labour government's first term in office. The government does acknowledge that this is a really complex area and that any change will require a full and detailed consultation. So they express this as a longer term ambition, but I do still think it's important to cover, because what they're planning to do is to remove the current 3-tier system for employment status and convert it to a 2-tier framework. And the current system is based on 3 categories of employment status. So we have employees, workers, and self-employed. And the level of employment protection that's afforded to each is dependent on their status. So workers' rights are inferior to those of employees. And at the moment, workers can't claim unfair dismissal. They can't claim statutory redundancy pay. They can't make flexible working requests or take family leave. And in practice, what we found over recent years is that this 3-tier system does cause confusion. And it's not just for employees, also for employers. And there will always be, the government says, a small minority of employers who are seeking to exploit that confusion to avoid their legal obligations. So the intention is to simplify the law and move towards a 2-tier framework, which will differentiate only between workers and the genuinely self-employed. Essentially, this means combining the category of worker and employee into one, and preserving the distinction for the self-employed. And the new category of workers will all have the same rights, including the right to claim unfair dismissal and receive holiday pay and sick pay, etc. So in practice, what this means is an upgrade, a significant upgrade in workers' rights to bring workers' rights up to match rights of employees, because it's highly unlikely that there would be a reduction in employees' rights. The new government has also indicated an intention to strengthen rights and protections for the genuinely self-employed, and they intend to give them the right to a written contract and to extend health and safety protections, etc. So I did just want to mention those because I think they are of really great significance, but just much longer term ambitions for the new government. That brings me to the end of my section. I'm now going to hand over to Malini, who will take us through some of the immigration aspects.
Thank you, Helen. So it was interesting listening to Helen and Dan and the kind of specific nature of some of what the recent employment bills have been putting forward by the Labour government. I think comparatively, from an immigration perspective, there's a real lack of detail, both in the manifesto and in the new border security, asylum and immigration bill that was announced in the King's Speech. As an immigration practitioner, I question the immigration part of the bill because there wasn't a huge amount relating directly to that, other than asylum related changes that they are due to be making. But generally the approach to the King's Speech has maintained the theme of the manifesto, which really put forward very general policy aims that the Labour Party are hoping to introduce in their term. the key headlines for them are in terms of reduction of net migration figures, the reform of the points-based system, which was actually first introduced by the Labour government, but subsequently adapted in numerous ways on numerous occasions by Conservative governments in the years that followed. But I suppose the two main bills that were announced in the King's Speech is not only the Border Security and Immigration Bill, but there was also the Skills England Bill, which I think, whilst it didn't directly make any reference to immigration, will certainly have a knock-on effect in terms of how policy will be shaped and the effect that will have on immigration to the UK. So this first slide was really just providing the key points in terms of really relying on the manifesto and what Labour had put forward as to what they were hoping to do. In terms of the business, there has been, as you may well be aware, there have been some significant changes, particularly for sponsorship and bringing people to the UK to work for UK employers, in particular the salary thresholds. Whilst not mentioned in the manifesto, it was something that Labour had, whilst in opposition, said that they were going to do in terms of looking into the effects of those increased salary thresholds, as well as linking to some of their employment proposals, really a focus on reducing abuse by employers and recruitment agencies in terms of the reliance of migrant workers. These are quite long-term strategies. I don't anticipate any immediate significant changes to immigration. It may well be that they want to bed in a little bit, given how much of a political topic it is. But moving on to the main, as I said, the main kind of headline aim that Labour had put forward, it was about a reduction of net migration. So when these net migration figures were last reported in December 2023, net migration stood at 695,000. And that is in comparison to the Conservative aims of bringing net migration down to a couple of hundreds of thousands. So, I mean, you don't have to be a mathematician to know that that's quite a significant and stark difference. Now, importantly, Labour have not set a migration target. I think that is important because I think there's a recognition that these are movable things and that there is a need for immigration in the UK. But interestingly, because they have not announced any kind of significant provisions or changes in law, if they were to keep things as it is and keep particularly the more recent Conservative government changes, the effect of that is likely to bring net migration down to 350,000 in the next 5 years. Now, which would be a win on the Labour's part, which I'm sure they will take credit for. However, this comes at would be as a result of really significant changes to particularly the skilled worker sponsorship and the ability for individuals to bring dependents to the UK if they were here as students or in health, working in the health and specific health and care sector roles. So that. In addition to that, I think particularly the skilled worker minimum salary threshold, which was introduced in April this year of 38,700, has had a real knock-on effect as to the viability for businesses to be able to bring in overseas workers and to maintain and keep salaries at that level, as well as for those on a more personal route, looking to bring family members where the minimum income threshold is at £29,000. So there's a question as to whether the policies that are now in existence are going to continue to be workable for businesses who do have to rely on overseas talent in order to meet, certain projects or aims for the business in the UK. So we'll see what that happens. But moving on to the scope to reform the points-based system, again, I think the main emphasis here will be on the skilled worker sponsorship route. There is going to be a need for this new government to focus on areas of shortages, particularly in a post-Brexit world where we don't have free movement anymore. And that's including sectors like hospitality, construction, IT, and engineering. And interestingly, I think, and this is where the new Skills England bill may come in, I think Labour's current approach is to potentially focus on upskilling and training resident workers in the hope that they can fill those shortage gaps. but that does take time. And so that, that can be a generation away. And so there is questions as to what can be done in the immediate future to address that. And I think importantly, as employers, there is also going to be scope for the government to be expecting employers who do rely on overseas talent to train up resident workers as well. So you'll see that they are looking to end the shortage occupation list where employers don't show action to train up kind of UK labour force. And that will come through, those kind of discussions and proposals will come through this link to these national skills bodies, including the Industrial Strategy Council and the Department of Work and Pensions, to identify, where skills are lacking, and particularly what parts of the country the skills are lacking. And, there's always a hope that they may well introduce more regional based immigration policies depending on sectors and skills. So focusing a bit more on the immigration policy and the EU, unfortunately, I don't have any good news for you. There wasn't any particular reference to specific EU type immigration policies. The EU settlement scheme obviously has been in place for some time now, so there will be that continued rollout for automatic consideration of certain grants of status. That is still something that has to be a discussion point sometimes, because it means that some people may only be granted status at a later date when they were actually eligible to be granted to it. But there is still the a kind of easier implementation of amended right to work checks as well, and right to rent checks. I've mentioned the youth mobility scheme because there was a discussion in the lead up to the election about whether there was a scope for a UK EU scheme for young people to allow them to come and work and experience life in the UK. That was unfortunately dismissed by Labour, but there was potentially scope for creating these kind of arrangements with individual member states. So it's a bit of a watch this space type moment. There are other government parties that were really for it. And I think this does link to those skill bodies to identify where there might be skill shortages, given our historical reliance on particularly, I suppose, young EU nationals who are wanting to work in things like hospitality, construction, leisure, that kind of thing. So hopefully a bit of a watch this space type category. And then I think finally, I just wanted to go through my wish list of what we would like the Home Office to consider, and this may well resonate with a lot of you. You may well have your own ideas as well. Really open to hear them. But in terms of what we would like them to be thinking about, I think the most key priority is really about the current and immediate skill shortages. It's not just about the fact that net migration is high. It's about why there is a need for people to be coming into the UK and for UK employers to be relying on these people. And yes, whilst there are intentions to upskill resident labour force, there's still an immediate need in certain industries to fill very urgent gaps, particularly things like health and social care. It'd be great to have the UK become more attractive to international students again. Students always kind of take a hit when it comes to immigration policies, but there seems to be a lack of acknowledgement as to the reliance on students when they graduate, as to the temporary workforce that they provide to a lot of UK sectors. I think probably one that probably resonates with a lot of you who do deal with immigration is the reviewing and reduction of immigration costs. Immigration visa fees, the immigration health surcharge, they all have increased significantly this year, and that has undoubtedly had a knock-on effect on a lot of businesses as to whether they are able to maintain those costs, as well as the corresponding increases in things like salary thresholds. So that is certainly providing a great deal of obstacles to many clients that we are dealing with. I think particularly with an EU focus, where historically those costs just haven't needed to be considered and unfortunately are having to take effect now. And then I think finally, there is a need for a genuine kind of entrepreneur-friendly category for allowing whether they be seasoned business people or new startups, new co-founders, to come and use the UK as a real hub to set up and establish and potentially create jobs for resident workers, which seems to be a key mission of the new Labour government. So this is our wish list. That, you know, we have a few years to work on it. Let's see what we can pull off. But I would really encourage, if you have the opportunity, whether that be through the French Chamber or through your own avenues, to have those conversations and try and push those things through going forward. But that's it on the Labour. Much shorter, much less detailed than the employment side, but hopefully helpful nonetheless. And I'll pass back over to Francois.
Lovely. Thanks, Malini, and thanks to Dan and Helen. A fantastic summary there of some detail and some lack of detail, but really, really helpful, I think. I hope everybody found that interesting. I have got a few. We haven't got long, but we do have a few questions which have come in, so I'm going to field those straight to you, if I may. So probably one for Malini, a question around whether the settled status is likely to be recalled or reviewed in any way, and if so, do we have a sense of what might replace it? My thought would be no, but
yeah, no, certainly not anything that has been mentioned in the manifesto. Not something that I think would be put forward by the Labour Party. I think that you know, that would be not necessarily just also UK domestic law, but also part of the withdrawal agreement was the basis of that grant of settled status. So settled status can only be lost by an individual if they're outside of the UK for 5 years or more. It doesn't matter if they don't apply for citizenship. Not everyone wants British citizenship, and particularly EU nationals. That, you know, they feel quite strongly sometimes. That shouldn't get in the way of the individual maintaining their settled status, though. So I don't anticipate there being any real changes to the existing scheme.
Fantastic. Thanks very much, Malini. I think this question is likely to be for Dan. Do we expect the apprentices' minimum wage to be brought in line too?
Actually, I will pass that over to Helen, if that's okay, because she dealt with the minimum wage. Yeah.
Thank you. I'm afraid I don't have very much to say on that. I'm not aware of anything specifically in relation to apprentices' minimum salary. I do know that the government is looking at these issues generally. For example, they're looking to ban the apprenticeship levy. I also know they're looking to ban, you know, things like they're wanting to ban unpaid internships. So it's definitely there, it's on the agenda, but I haven't seen anything specifically in relation to national minimum wage for apprentices.
Fantastic, thanks, Helen. And another one for you, I think, regarding the changes to flexible working and the day one rights there. Will that affect all businesses, right down to, you know, very, very small micro businesses as well? Is that all employees, all businesses?
The intention, as we understand it at the moment, obviously a lot of this is conjecture, but as we understand it at the moment, it will become a default position for all workers. So that's the starting point, and then I think everyone has to work back from that position. So yes, I think the answer is, you know, the short answer is yes, but I think we obviously have to see how that translates into the legislation, because at the moment we have got these, clearly there will be some circumstances where flexible working just doesn't work for a business. At the moment we have the 8 specified grounds where we can, you know, employers can refuse requests on those grounds. Yes, there will be a difference because we're effectively changing the burden of proof. If we're working from a default position of having flexible working and then having to show why that doesn't work, it's going to be a different situation. But I suspect we're going to end up with some genuine reasons why flexible working doesn't work, and the employer will be able to invoke those reasons. We just haven't seen how that is going to play out at the moment, but clearly there has to be some kind of practical exception to that as a general rule.
Thanks, Helen. Thank you. So just a reminder to everybody, please do, any questions, please do put them into the Q&A box within Zoom. So type into there and we'll try and get those responded. So I've got another question which is coming. How do you think the UK can be attractive to international students again? This is a question, you know, hot topic. I mean, we've touched on it. We have, as a chamber, have a lot of conversations about this, and clearly the overarching objective of the previous government in terms of net migration numbers really impacted their position on this, I think. But any thoughts on changes to youth mobility, visas, that kind of thing?
So I think think that's always been something that, again, a practitioner's wish list post Brexit. I think it was always there was a recognition of the importance of not just students but also graduates to be able to freely move, just for cultural experience, but also the UK really benefited from that type of workforce. The Labour Party have been very careful in a post-Brexit to really put forward any different position to what the Conservative have done. I don't know if that might have been a strategic thing in the lead up to the election, given the kind of voters that they were trying to attract. And I think that, personally, it's my personal opinion, that's very much in line with how their position on immigration as well. I think it was very neutral. Given their historical positions. It will be really interesting, though. I think one of the points that I was thinking about is, particularly in relation to the Borders and Securities Bill, they will need to work and negotiate with EU member states to put certain things in place. And I imagine immigration will be a real negotiation tool. In terms of, what the UK would like to put in place and what the EU member state is happy to accept, and what they would like to see, as a result of that. So I wonder if things like the youth mobility or the free movement of young EU nationals will be put in place, because the youth mobility scheme as it stands is with very specific countries, which is why I can see the Labour Party didn't necessarily want to sign up with the whole of the EU, and may instead look at specific member states and looking at arrangements with them. But we'll just have to wait and see, I'm afraid, Francois. I'm sorry, I can't I can't really give much more than that.
That's absolutely fine. Thanks, Malini. Not a direct question. I wanted to ask as well, just your perspective, your thoughts on the changes that are proposed in all of these in these bills versus the overriding desire of the new government to focus on growth and focus on reboosting the economy. I mean, it felt like quite a lot of these changes really put more costs and more burdens onto business. Maybe not cataclysmic, but it's certainly in the wrong direction. Just any personal reflections from you and the team on how this might play out in terms of boosting business versus leaning too much on business?
Well, I can start by replying, Francois. I think that's a really good point, because yes, Labour has made it clear that it wants to focus on growth and wealth creation, and then you look at some of the proposals that have been announced and you think, well, that's just going to put more burden on employers and create more costs. So it's a difficult one to balance, for sure. They're talking about the biggest upgrade to workers' rights in a generation, but we will have to see how these things are dealt with following consultation with stakeholders as well. The only thing I would say in relation to some of the changes is just looking back to the last Labour government, when they brought in the national minimum wage, these same types of arguments were rolled out, that the minimum wage would create stagnation and more costs for employers, and it didn't seem to have that impact, and we went through a period of good growth at the time. So there shouldn't be an automatic assumption that these things will lead to stagnation, but I think there are some valid points being raised by people who are skeptical about some of these measures as to whether they will genuinely increase productivity and growth, or whether they will have some unintended consequences.
Yeah, perfect. Okay, there's a one final detailed question that's come in. I'm going to suggest we deal with that offline, and I'm really conscious of time as well, and making sure people have the opportunity to get to their next meeting. So just a huge thank you from me to all the team at Door Clayton, to Helen, to Dan, and to Malini. Really fantastic job. I hope this has been useful and a really good summary of some of the changes that we're anticipating in the next year. So for all of our members, if you have any kind of questions or queries about any of this, please get in touch with ourselves or to Door Clayton directly as well. And as a chamber, we're always on, happy to receive and field any kind of questions anytime. So just a huge thanks from me, a kind of virtual round of applause for the Door Clayton team. Thanks to the French Chamber team for pulling all of this together and running it so effectively. And I wish you all a very happy summer. Thank you. Thanks, everybody.
Thank you.